the contracting parties agree in a mediation, a commercial mediation, then that agreement is enforceable, just like a court award. That's how far we have gone with mediation at the international level. Mediation is non-binding. Parties can walk away with it, and later I think we are going to be talking about power imbalances, the downside of mediation. It's not a panacea for everything. It has downsides. It has also a positive side to it. It's not quick, especially if parties are going in there to fish, but it can be as quick as an hour, 10 minutes, can be, but it's cost effective. And a lot of you have been trained in mediation. I was trained by FIDA. Original members of FIDA were Muigwa and others. They took us to school and they took us through that. And I've seen it work in family disputes, commercial disputes. The chair and I sat in a task force that came up with the ADR policy. The ADR policy now is somewhere before Parliament. It's going to be a policy soon. And then there is a TDRM policy which is being rolled out. Okay? The judiciary, and I think you've been hearing it the whole week, have rolled out mediation and TDRM across the country.
Brilliant. Thank you. Thank you very much. So I hear you saying two things: that mediation really improves access to justice.
Yes.
And that it promotes the rule of law.
Yes, it does. You have to look at mediation within the context of the rule of law. What we have been doing over the years is to get a framework within which mediation can work without formalizing it, but answering to this. Does it promote access to justice? And something else, sustainable development.
So what I'd like to ask, flowing from the foundation that you've laid, and this is to you, Judge. From where you sit as a judge of the Environment and Land Division, when we speak about the rule of law, and when we speak about the rule of law in relation to climate mediation processes, lack the capacity or legal literacy to participate meaningfully, are we really promoting the rule of law by the use of mediation?
Thank you, Chair. First and foremost, what Prof has said, Section 22 and also 23 of the Climate Change Act has now given the court, the LC court, powers to undo climate litigation disputes. Section that 23H also talks or speaks to mediation, to arbitration, negotiation, and so on and so forth. As of January this year, we only had around 1,400 cases on climate change litigation across the world. In this country, until we had the Climate Change Act, a lot of cases which have faced our courts are on nuisance, on pollution, on negligence. Apart from now, the two cases, there are two cases on climate change litigation which are pending and which I will not venture into because they are live cases. One of the things we've seen from our courts is lack of expertise, knowledge, and also ignorance on climate rights and also climate duties. Because when you look at the Act, it is now on defining who are the duty holders insofar as climate, what are the duties, climate duties, climate obligations, and so on and so forth. And therefore, even when you're handling mediation, obviously when you do not have the background, for example, Judge Kosibor has said there is a lot of ignorance of the law. ignorance of the legal rights, statutory rights, constitutional rights, socio-economic rights as enshrined in our constitution. And therefore, even when you refer matters for mediation, the question is, are they equipped? Even the parties, as you take them through the mediation process, do they really know their rights? And somebody mentioned about the case of a success story of Okaria 4, where the Maasai's Okaria region with Kienjen went into mediation, and they settled that issue of geothermal. The question is, was there equality of arms? Even when locals are coming and the marginalized are bringing those cases and are going through arbitration, do they have the knowledge? Do they have the expertise? Do they not need, for example, expert determination to assist them in the course of the mediation? And also, what about the mediators? When we talk about climate change, we are talking about the intersex between science and environment. How many of us are aware of mitigation concept, adaptation concept, and also resilience concepts? Thank you.
Thank you very much, Judge. Your answer is troubling from where I sit. And so, Teresa, I'd like to ask you this then. In truth, is there a risk that mediation is actually being used to bypass legal accountability and judicial scrutiny under the guise of consensual mediation? Is that a risk that we should be concerned about?
Thank you, Chair. Yes and no, I think. I think it's one of those issues where you can't have a clear-cut answer, and I'll explain why. I think it's important to understand that when we do talk about mediation, particularly in the context of climate mediation, often we are talking about a vulnerable party and a party that's not as vulnerable. And I think it's important for us to begin to problematize what we mean by vulnerability in the context of climate change, because the assumption is, the tendency is to oversimplify, right, what vulnerability means. And which is why often when we say vulnerability, usually it's vulnerability equals men, women, and children. And yet it's more complex and more complicated. So from where I sit, I think the first thing to acknowledge before we get into whether or not mediation will facilitate exclusion is to understand that for any dispute, right, where there's two parties and there's a risk of there being an unequal power balance, we are going to have issues. And I think what that requires is, for the parties going to mediation, it would be ideal if everybody was well informed of rights and positions, but also for the mediators to always carry at the back of their mind that even as negotiations are ongoing, the parties may not necessarily be equal. And it's important to problematize the issues, but also to problematize the responses, right? So for example, I think it was Judge Board this morning who was talking about a case that was ongoing, and I think in Laikipia, she said, where you had, these people that wanted to run a conservancy versus the community. And of course, the knee-jerk response would be, oh, the community was vulnerable because, they are in the community, they don't have information. And yet, communities have agency, right? They've lived in the area, they have certain rights and access. And even as you begin to negotiate, you must locate the negotiation from perspective of, this is not about an individual community, but this is about a broader discussion. So if you're going to set up services, for instance, you don't look at it as conservancies and the rights of the community, that particular community, but locate it in the broader discussion around, there are traditional imbalances that make indigenous communities, that make communities of margins of society not able to advance their rights of their own accord. So I do think that to the extent that you are, sometimes directing mediation for the courts, it's important to locate it in the context of, do these parties actually have the capacity to equally negotiate. Because remember, when we're talking about negotiation and talking about the promotion, rule of law principles, we have to think about equality, we have to think about fairness, we have to think about justice. And if you're thinking about that, I think it's then incumbent on the parties that go to mediation, or the mediators themselves, to have that at the back of their minds, even as they direct the mediation. So there is a risk, yes. But do we throw it away completely? I don't think so. Sometimes those are the platforms then that as the negotiation and the mediation is going on, parties are able to get more information during the course of that process in, I think, an environment that's not as combative, as it were, as a normal sort of legal suite before the judiciary. So that would be my response.
Thank you. That's very interesting, finding or trying to balance the tension between vulnerability and the promotion of mediation in areas where there is clearly issues with power imbalance. Talking about power and imbalance and tokens, Senior Counsel Kioko Kilukumi, you chair the Energy and Petroleum Tribunal. And what I'd really like to understand from you is, from where you sit, and given the players that come before the tribunal, how do you balance the needs of consumers against what may presumably be national interests and what may be significant corporate interests in terms of realizing the continuing viability of, say, public utility companies and the need for consumers to be able to enjoy the services that those utilities offer? How do you balance them, and how does mediation assist you in balancing those interests?
Thank you, Chair. In the Energy Tribunal, there are disputes that come before us from the energy and petroleum sector. And the disputes that come to the tribunal are first dealt with by the regulator, that is EPRA. The regulations require that before you approach the tribunal, you must first go to the regulator. The regulator has a mechanism to resolve disputes. Part of that mechanism includes mediation. And before the matters are escalated to the tribunal, a mediator is appointed, and this mediator must render a decision within 30 days before that dispute can come to the tribunal. Now, there are vulnerable groups, particularly the low-income population. You will find somebody's power has been disconnected either for non-payment, or there is a dispute about that. And so when the matter has been dealt by mediator and there is no resolution and it comes to the tribunal, now we have to balance two things. Power is essential. Somebody has been left with no power, and therefore they cannot do the ordinary things that require the usage of power. But power must also be paid for. Kenya Power, for example, the utility company, there are many Kenyans who have shares there. The Kenya government itself has shares there. If power is not paid for, that company will ground to a halt. And so you must balance the needs of the vulnerable, the power consumer, and the need to have this important utility company running. And so we are many of the times forced to balance that. We may order that your power be reconnected on condition that you pay a certain percentage of the bill that is disputed. And that is as much as we can to balance interests of the two of these parties. Thank you very much, Chair. That's all I have to say.
Thank you very much. So what I understand you to be saying is that you have a very limited remit in terms of being able to assess whether or not the processes that took place before the matter came to your tribunal were processes that enabled the parties to come to an understanding that meets the needs of both parties. Is that correct?
Yes, we have a limited power in the sense that we are dealing with this matter as an appellate tribunal. The primary issues are being dealt with by the regulator. We only deal with those matters on appeal. And like every legal practitioner would know, when you go on an appeal, the appellate court has limited powers to deal with a dispute. They will only deal with what has been brought up in the appeal.
Very well.
Thank you.
Very well. Lois, you're from Zambia. And I know that you're presently experiencing a severe drought, which has, of course, led to water shortage and therefore interrupted your ability to enjoy continuous electric power, which I hope you're enjoying in Nairobi. Now, given the effects, and presumably this is the effect of climate change, what nature of disputes have arisen that you can identify arising from that lack of, or from that drought and from the lack of energy?
Perhaps just to throw this in, when power went out twice when the last panel was on stage, those of us from Zambia did not flinch because it's a very, very common occurrence for us. And I think Zambia provides a very interesting case study of the connection between climate change, energy crisis, and really just the impact that it can have on a country. In Zambia, it's a national disaster. For the last 2 years, we have experienced a drought that has affected our largest river, the Zambezi River, on which we have a hydroelectric power dam. Now, 84% of power in Zambia is hydroelectric. So when the levels in that dam, dropped to just the worst levels we've ever had since that dam was erected, it has just created so many disputes in our country, such that to even link the number of business disputes we have in our courts because of low productivity and the impact that the lack of power has had is something that we've noticed. The courts are not drawing that link. They're not making the link, and lawyers are taking these cases to court simply arguing about contractual breaches, and no one is actually looking at the impact of the fact that we would go 21 hours without power in a day, and how has that impacted businesses, and how is that linked to climate change. So for me, it's the link between all those things that I feel the courts have not been able to fully address. And this is why we need mediation, because mediation doesn't just look at the tip of the iceberg, but it goes, to the underlying issues. And if we can trace some of these business disputes to the climate, the climatic environment in Zambia, I think we would have better resolution and we would have more creative solutions. I'd like to just draw an example. I mean, there are numerous disputes, but drawing from the hydroelectric situation. So we have a private power plant that actually uses coal to produce power. And because of how bad our power situation was, our electricity supply corporation entered into a power purchasing agreement with this particular private institution. And obviously, things have gotten worse, and our electricity corporation was not able to pay for the power that they were purchasing, obviously because they were not producing enough power. And in the contractual clause, this matter had to be taken to the London Court of International Arbitration. And so this matter went there. Obviously, millions of dollars being spent in arbitration. What does that do for the nation? And so it took, the intervention of the president, and he had to have a closed-door meeting with these two parties in dispute. And I would like to believe that what occurred there was a mediation, because the next thing we heard was that a consent award was filed into the London court. And so we are experiencing issues, at a national level, but also just at the grassroots. Everyone has been affected by this power situation. But whether this is really being considered in the dispute resolution process is something that, from my understanding, is not really coming to the fore. And I think mediation is the most appropriate mode or mechanism to actually address the impact of climate change on, our energy situation and how it's affecting businesses and livelihoods in our country.
Oh, that's very interesting. It's very interesting. And talking about dams, power production, and the availability of water, Janet, I just want to turn to you because at the Water Resources Authority, I presume that building dams or authorizing the building of dams or facilitating the building of dams is one of the things that you engage in.
Yes.
What are the parameters that you take into consideration in terms of resolving any conflicts between local communities and potential infrastructure development within the context of your statutory mandate?
Okay, yes. So the Water Resources Authority is the regulator on behalf of the national government responsible for regulating the management and use of water resources across Kenya, which then means we are taking account of both groundwater and surface water. Kenya is classified as a water scarce country, which ideally from the global perspective, it is one country whose water resources are quickly diminishing. And therefore that poses the risk of conflict resulting from the usual demands for water resources, irrigation. We have a domestic supply, including public supply. We have the water that comes to your tap is also competing for the water resources for which we are looking to allocate for energy. So in terms of balancing these competing demands, then the initial priority is given to domestic use so that the immediate need for domestic requirements are addressed, obviously taking into account what needs to remain for the voiceless, the snakes, the frogs, and all that is benefiting biodiversity. Yeah. The ones that would not be able to defend themselves. And again, that speaks to the question of one of the factors around climate change. We have biodiversity loss, we have pollution, and of course we have climate change issues that directly are impacting water resources. So areas that have been predisposed to flooding will, as a result of climate change, obviously experience higher levels of floods. We have experienced rising sea levels as one of the impacts of climate change. And within Kenya, we have seen the rising, and it's unexplained really scientifically, although it's attributable to effects of climate change, the rising lake levels in the Rift Valley lakes. We have rising lake levels in Lake Victoria, and that has displaced communities around those affected areas. But turning to the question of how you balance, then, is that we have the competing needs, as I have said. When at the community level, we have established community associations that are known as Water Resources Users Associations, drawn from community members benefiting from these resources that are instrumental in giving comments. For example, if an application has been received by the authority for purposes of hydropower generation, then comments from those associations would be useful. And factors such as historical knowledge of the existing resource, how much it has diminished over the past, would be taken into account over and above the technical reports, including hydrological reports that would be undertaken by experts within the field, such as hydrologists, that would go and say, in the past 2 years, then the water levels have reduced, the demands have increased, and therefore we need to make a balance between the demands that would go towards hydropower production and already existing demand, so as to mitigate conflicts. And ideally, mediation would come in handy in such a scenario where there are competing community demands or vulnerable communities and a need for a project which, by way of a dam then, would address both impacts of floods by way of putting a dam as a mitigating measure for floods. But in terms of drought then, the vulnerable community would have the dam that would be supplying electricity for the contractor that would have put up the hydropower dam, but still have a benefiting aspect to the community by way of supplying. We have an example of a dam that is currently being put up within Kwale County, the Mwache Dam. I don't know if some of you have had fit to see what it is that the government is doing. And one of the interesting possible conflicts that would have arisen was that the site of the dam is located within the kayas of the Mijikenda community. And one of the scopes that the dam addressed was that we need to respect these traditional and historical sites that acknowledge that these are prayer sites and all that. And therefore, discussions and negotiations around that need to undertake certain rituals before they give up certain sites or certain of those kayas, and an agreement was reached. So something like that would greatly benefit in the event of a conflict, would greatly benefit from a mediated process. Thank you.
Excellent. I think that's a really good success story. Do you have any failures?
Kenyans are highly litigious, and some of the projects, yes, have faced resistance by communities, acknowledging, of course, that the government sometimes would have come by way of, we know what is necessary for the community, and therefore we have identified a site. Like, I'll give an example. I know it's actively before court now, so I'll limit how much I say. But in terms of what the government has planned towards putting up dikes and dams, then a site was identified, but there wasn't extensive, I would say, public participation. And as a result, the political class went and said, resist this infrastructure because you're not being compensated, your land will be taken away and all that. But it overlooked the aspect that we constantly see in the media, a lady crying of Serikali Saidia. Yet when the Serikali comes to Saidia, I'm sorry for those that do not understand, it means the government should help, but when you translate it, you lose the whole joke about it. But it's not a joke. It speaks to the dignity of the people around those areas that have been affected by floods, so that the question of public participation in incorporating the rule of law then should not be downplayed, even though we are looking to address human and human rights violations, so to speak, and to address the dignity in which people live. Yeah.
Thank you. Thank you very much. Now, Judge, I'll just come back to you because in response to my first question about promoting the rule of law, you acknowledge that the lack of legal literacy may be an impediment to the wholesome resolution of disputes through mediation, especially in climate-related matters. So my question to you is there, and I want to be as delicate as possible with this, is there a risk that we are merely tokenizing these outcomes when they're, or are they truly shaping outcomes that are holistic, that meet the needs of communities when we engage in mediation where parties potentially do not have a 360-degree appreciation of their rights?
Chair, the philosophy behind mediation, as put by a professor, is the freedom of parties to negotiate and enter into contracts. Obviously, and I think the framers of our constitution and Article 159 left that, because judicial power is donated by the people. And that power can be exercised through the executive, through the legislature, and through the judiciary. And if parties in the same constitution have said that we have a residual power, what I think Dr. Nancy Mbaranza was saying, law behind law, that residue power where they want to share or co-share the power to determine and enter into contracts. In my view, we cannot then say that mediation is tokenism. In my view, it is the people who want to determine their matters. And remember, the day before yesterday, we were told you can give a paper judgment which will not be implemented. And even when it is implemented, there are underlying issues. If then people will come up with a mediation settlement agreement, and it's good for them, in my view, obviously, they should be given that liberty. At the same time also, there are certain complex disputes like climate change. In my view, these are very complex issues. And that is why the ELC court for the last 1 year has been trained on these emerging issues so that the courts are well equipped with the toolkit to handle these complex decisions or disputes which are where there is an interplay between science, property rights, and also, environment. And environment is wider than a contract. Obviously, it means then even the mediators, we have to, and the tribunals, the water tribunal, for example, because the law says that before we handle the matter, we check whether the doctrine of exhaustion, you have exhausted the alternative dispute resolutions, water tribunal, energy tribunal, NEMA, NET, and so on and so forth. So even when you come to court, obviously we will ask, and this is what the Nicholas case, the Supreme Court has said, even as people bring their constitutional, disputes, we must be alive whether the tribunals have the capacity to determine those issues, such that then, even as we say we want to co-share this power as courts with the tribunals, with the mediators, do they, for example, have the capacity to give constitutional edicts, for example, structural edicts, and so on and so forth? Thank you.
Thank you very much. Thank you for that holistic answer. But your answer is premised on the fact that the Constitution gives the power to the people. And I accept that. But what I really would like to ask then, following on from your question, and maybe I should ask you, Prof, even though the people have the right to determine what it is that they want to negotiate in the context of climate change, in the context of the environment, and so on and so forth, are there certain rights that you would consider non-negotiable and so therefore should not be subjected to mediation, even though the community may be willing to trade them off for economic benefits?
Let me continue from where I left, but in answer to your question. There's a gentleman called Owen Fiss, F-I-S-S, and he wrote a powerful article to the effect, he says the article is titled Against Settlement. And he argues all these things called ADR, we shouldn't have them. Mediation, we shouldn't have it. Conciliation, we shouldn't have it. And you see, if you begin by asking yourself, why should we not have mediation? I think you'll get somewhere. It takes me back to the issue of the rule of law. Mediation must be practiced within the context of the rule of law. And the rule of law is what here? We are talking about rights. Your constitutional rights, if you are in Kenya, should not be violated by mediation at all. We are talking about respect for human rights. And of course now there are environmental rights. Did we talk about the rights of animals? the rights of all that biodiversity. They should be respected. Why? It's constitutional, and you are in Kenya, okay? And even if you're not in Kenya, there's the Universal Declaration of Human Rights. So that cannot be wished away. And we cannot have mediations that negate human rights, the mediations that trample on the vulnerable. There must be inclusivity. That's also constitutional. So you're looking at a framework that supports mediation for its positive outcomes when it works, and sometimes it doesn't work, but it has to be within that framework. What is the framework? Article 42 of the Constitution, the right to a clean and healthy environment. Amazingly, it became a right just the other day. We've been fighting for it for over 15 years. Now it's a human right internationally. So you'd have to negotiate those things within the context of Article 42, Article 43, Article 60, Article 69, Article 70, and 71, and so on. Within, that is our own constitution, of course, in addition to Article 159. So you are saying that you must be looking at access to justice, attainment of sustainable development goals, and we have 17 goals, 17 only. So mediation then that steps out of that is not very useful. Mediation has downsides. Big corporations come into mediation to just hide and try and find out what is the other side saying. And I told you out there that sometimes mediation is a scam, because the bigger, the more powerful person is coming in to just hide away and find out what is it you know. So we must be aware of that, but at the international level nowadays, if you have a mediation agreement, you know you can now enforce it like an award because of the Singapore Convention. We've come very, very far. And then nationally, we have now the ADR policy. So nobody will ask you, where are you coming from? And there's one thing about mediation. There is collaboration. It enables people's voices to be heard. Those villagers will come in and say what it is they want to say. Recently, because of the concept of ESG, environmental, social, and governance, that you must take care of the environment, you must take care of the society, you must take care of governance, including human rights, you then find concepts like mediation have taken roots. You cannot start a project, for example, within a community if you do not have what is called the license to operate. License to operate. And there is something else called FPIC, free, prior, and informed consent from those people. And we know it. And a lot of the oil and gas contracts have, for example, arbitration between two parties. Then you find you have a community. So what do you tell that community? And you see, our law is not that friendly. It's from in 1901. The king comes and appropriates the whole land. Why? Not for the benefit of the people. No, Africa itself is also like that. If you look at DRC Congo, we have all the green minerals coming in. 20 of them. But how poor are they? As late as last week, we have 5-year-olds mining in there, human rights abuses. So you cannot now call that 5-year-old to a table and say we are mediating. We are not. You must take care of their human rights. And who can declare their human rights? The courts, the international courts and tribunals. At the Africa Union level, they advocate mediation, but within the frameworks that emphasize the rights of those poor and vulnerable people. Article 10 of Rio also has public participation, but we also know that public participation is not enough. You have to put in other tools like environmental impact assessment, environmental audits, strategic environmental impact assessments, biodiversity impact assessments, climate change impact assessments. So you go beyond law to science. Thank you.
Wow, very interesting. So, you know, when the most prolific writer I know on mediation and the environment says that mediation could potentially be a scam, I have to sort of take a step back. Let me come, with those in mind, Teresa, let me ask you. So, do you think we can really mediate then the tension between renewable energy and conservation? Or does this actually avoid the deeper political question of who decides what is green and for who?
Do you want the politically correct answer? Or
I want the answer.
I think the politically correct answer is, of course, we should be able to negotiate and discuss when we talk about green energy. But I think the politically incorrect answer is that when we talk about renewable energy, we must think about the context in which we're talking about renewable energy. I remember I think it was the year before last when we had the Africa Climate Summit. And one of the trending topics at that time was the whole question of transitioning to green energy. And I remember in one panel, I asked the question, what are you asking African women to transition from to? Because they are still energy poor and we're already talking about green transition. Why am I saying this? I'm saying that, you know, when you think about, I did speak about vulnerability in the beginning. I think that it's important, already said, that when we think about mediation, we must think about it in the context of sustainable development. So even as we talk about renewable energy, the conversations with the communities where you want to spearhead the initiatives must be inclusive, they must be participatory, they must take into account the realities of the people that are going to be affected by what we do. I know that in recent times we've heard of, you know, whole tracts of land being taken across the continent for carbon sinks. And yet when the disputes come to court, often we are not talking about the environmental and climatic change issues related to those matters that are before the court. Often it's, oh, we have a dispute because we agreed, you know, 20 years ago that we would take this conservancy and would be able to extend the agreement. And what comes before the court is a contractual agreement. And yet behind it, there are, you know, climate change issues, there are environmental law issues, there are issues of exclusion, there are issues of lack of voice of, you know, affected communities. So I think that mediation we should not only think of mediation in the context of the dispute at the end of negotiation, but really deal with mediation from the beginning of a process, right? So if, for example, we are going to talk about mechanisms for renewable energy, whether we are thinking about, you know, now we are talking about geothermal power, we are talking about wind power, we are talking about solar fields. I think the starting point should be, what are the negotiations around the communities that are affected or that have access to the places where you want to start these initiatives? To what extent are the communities empowered to engage in the agreements, in the community development agreements as they are called? To what extent are they empowered to have meaningful, and you called it FPIC, Professor, right? Free, prior, informed consent. To what extent are communities empowered? And I think that's where some of us come in, because I think to work with communities, the focus becomes on ensuring that communities are empowered. And across, as our colleague from the Water Authority said, as being very litigious, but sometimes it is important for them to litigate, to be able to protect their rights and to protect their right to access to the resources that are within their communities, but also to ensure their livelihoods. Because when we talk about renewable energy, we're also talking about who's going to access the renewable energy and to what extent have we made room and mechanisms for those communities to be able to access. So I think it's a discussion, but that requires empowered communities that are able to equally negotiate.
Excellent, thank you very much. So Lois, let me just come back to you before we open it up to the audience, because you really brought it home in the sense of how a drought can impact contractual arrangements beyond those envisaged by the actual contracts, and perhaps what the place of mediation could potentially be in relation to, and I'm told we have 15 minutes, so if you could give me a short answer. So what are the learnings for you from, as a Zambian lawyer, what are the learnings from you in terms of being able to reform either your contractual or your legislative framework in order to ensure that you mitigate against the effects of such a crisis?
I think for us, there has to be a coexistence between the courts and mediation service providers. Prof has said that, you know, in some instances, the stronger parties come into mediation and they misuse the process. So we must definitely be aware of how mediation can be misused. However, we do know that the court process is very restricted in what it can provide for communities and how it can resolve these disputes, because the court process is, you know, a win-lose situation. Whereas when we're dealing with all these competing interests, we do want a win-win situation. Zambia is a mining country. 70% of our exports are from mining. So we have so many competing interests. So we have, you know, our local businesses that depend on the mines. We have a government that depends on the mines for, you know, certain amounts of income. So there has to be a way that we have to address all of these interests and balance them out, as well as the interests of communities. And what we're seeing is that many times the communities and the community leaders are willing to sacrifice the interests of their communities because of poverty. And we know that's a very big problem in Africa. And so how can we balance all of these interests? I think the courts has to work with mediators to see how best. I think we need to analyze the disputes that are coming before the courts, and our judges, you know, and mediators need to have some synergy where portions of the dispute can be litigated and judges can refer some portions of the dispute to, you know, either court annexed mediation or private mediation. I think we need both. It's not one or the other. We do need the courts to uphold the rights of vulnerable communities, but we do need mediation processes to address the different competing and very valid interests that, you know, the nation has, as well as, you know, the livelihoods of individuals and the communities.
Excellent, thank you very much. So we'd like to open this up to the audience. If there are questions particularly directed at Senior Counsel Kyoko Kilukumi and Janet, both of whom are fast becoming authorities on this subject, and therefore will give you answers that address practical issues that might confront you. But if there are questions to the rest of the panel, please address them as well. There's a question here at the front. Pardon? Oh, yes, Judge, you're raising your hand on behalf of your neighbor. Okay. Did you engage in any sort of mediation in order to facilitate that? There's no conflict. We will soon know.
Thank you so much. My name is Director Lasoy Ambrose from the Ministry of Labor. I have a particular, okay, maybe for the benefit of the session chair, of the neighbor here, Judge, today is my eyes. I don't know if you've gotten that.
Yes,
but my question is directly to Professor Kariuki. You have enlightened something that can bring more attention, especially to mediators in this country. Mediators believe in a philosophy of win-win agreement. I agree with you about this committee of the mediation. What are your concerns? Is it around the existing enforceability of the issues, keeping in mind that we are believing on a cohesive resolution for both parties? Or is it a failure of the parties in withholding the decision made by a mediator? Thank you.
Thank you very much. Let's take another question so we can answer them right at that end, and then I'll come to this side. Microphone there, please. Right. There are two competing questioners.
Okay. My name is Honorable Felix Okal. I'm an elder and a certified mediator. I didn't want to talk much, but what I have here is the doubts our learned friends. I've seen here that the lawyers are doubting the work being done by mediators. Because where they say that we are like doing early work and they finish it, I don't agree with that. Because the parties talk to themselves and they agree. Yes, the other day you heard that most of the cases that were before the lawyers and advocates failed, and the mediators succeeded in sending them off peacefully and agreeably. So I still request that you give us time, because mediators are also, some of us are advocates. So if you are doubting them, then you are doubting your fellow people. Thank you.
Is there a question there somewhere? Let me come back to this side. Microphone, please.
Good morning. Good afternoon, everybody.
Good afternoon.
My name's Barnabas Maloba from Kakamega, and I'm keen to stick to the message of the annual mediation 2025, that we are talking about climate conditions and essentially land use and climate change disputes. And from my understanding, from what the panel this morning, Senior Kilukumi has strictly talked about, and also our colleague from Zambia talked about drought, rain, water, trees, soil erosion, about the ozone layer. And now that we sit here as mediators, with this being the scenario as it is, there's automatically a conflict between the original creator of the earth, who is God, and we, the human beings, who are the terrorists of this God's scenario. His plan is being interfered, destroyed, and as things look, it is we human beings who sooner than later will be extinct.
So what is the question?
So the question is, don't you think as mediators now, you ought to have literally also supplied us with trees to plant? Thank you very much.
Thank you. Can I have a lady, so that I don't run into problems with my friend Eunice Lumalas? There is a lady here.
Thank you very much. My name is Arbetha Kokach. I'm a gender specialist, and I do a lot of work on mediation in the communities. Being a gender specialist means that I wear gender lenses whenever I'm doing mediation, and I hold to my heart issues concerning human rights, especially the rights of women and other vulnerable groups. In mediation, we are often faced with a challenge, especially when you hold human rights next to everything. because we are supposed to be neutral, we are supposed to be impartial. I would like to be guided. How do you go about being neutral, impartial, when you know very well that these issues are important and you are tempted to take sides? I often find myself in that situation. May I be guided, please?
Thank you very much. Unfortunately, we're quickly running out of time, so I will ask my panel to take those. I think there were 3 questions. Prof, perhaps if you can take the first one, it was directed at you, and then somebody else can take the other 2.
We are discussing this morning something called climate change and energy disputes, a new area. Careful, careful, careful. Who is writing the script? Africa is the poorest continent in terms of dollars, but the richest in terms of resources. The richest. If we were to sell our oil and gas in gold, we would be the richest. Now, there's a narrative that is coming from somewhere else. And big corporations are saying we are going to go into mediation. And for the sake of the person who asked the question about the doubts I'm casting on mediation, I can tell you for free that I've written about 2,000 pages for mediation. I am one of those people who believes in it, and I still do. Because mediation has something unique. It can resolve a dispute. There's a difference between resolution and settlement. Resolution means it doesn't come back. It goes away forever. But we are in a new era, climate change litigation. The ESGs. Then ESGs by there are coming as ESG clauses from the World Bank, which then become arbitrable and negotiable. So we have to be very careful even when we go into that. Because remember, one of the downsides of mediation is the non-binding nature of it. So Israel, for example, went into a mediation in 1948 with the Arabs. They're still there in 2025. You can sit there, and you can also walk out. There are serious power imbalance issues that we need to look at, and corporations. And I can tell you, those who deal with corporations, they will never say no to mediation. Why? They want to know what the community is saying. But they're not listening, are they? We have huge projects, infrastructure projects, that come on and they're imposed on communities without that thing we called FPIC, free, prior, and informed consent. And then you get 1 or 2, 3 elders, and you sit them at a table. And you're purporting to do a mediation. I am saying caution, caution, caution. But where mediation works, it is the best. And it's the only thing I know that can bring parties to the table. Finally, mediation has worked internationally, and it has another name. It's diplomacy. Environmental diplomacy. And it's the only thing that can work, nothing else. Across Kenya and Uganda, about water resources, energy disputes, it is multilateralism that works. Nations get together and speak. They don't sue each other as such. And even the Permanent Court of Justice, the PCA, Permanent Court of Justice, and the Permanent Court of Arbitration. Just the other day, we had a conference there, and they are saying, let's look at conciliation, because it works for them, and it has worked for them. So mediation is here to stay. But please go and find out what are the arguments against mediation, because it's not a panacea for everything. And then use it when appropriate. If somebody needs an injunction, I'm a litigator. If somebody needs an injunction, somebody's about to demolish your building, you don't go into mediation. You sue the hell out of him. And then later on, you go into mediation. So I'm saying careful, careful, careful. It can work, it shall work. But in these new areas, do not be misled. Because Africa is looking like it will sit there. We have talked green, going green, going green. Africa will be left poor and disorganized. And I'm saying no. because I have the facts. And I have written books around it. You see where I am? So I'm with you. I'm one of you. But I am also studying this area very closely and not listening to the multinationals. Thank you.
Thank you. Thank you very much. Very informative answer. Anybody wants to take on the other question about neutrality, impartiality, and how to deal with the conflicts there? Perhaps? Lois?
Perhaps I could say we need mediators at every level, because not only is your neutrality important, but your ability to speak to power. We need brave mediators. We need mediators in government who are ministers. We need mediators who are CEOs. We need mediators at every level. There are some disputes that some mediators cannot mediate. We need to match mediators to disputes. So if we have a powerful multinational in the building and a community that really have no voice, what kind of should we choose for that dispute? We can't pick anyone. So the skill, the competence, the courage of a mediator to hold that space, be able to speak to a multinational, put them in their place, and bring fairness into the process. So I think that's what we need. We just need capacity of mediators in government, in all the arms of government, and I think that will make a huge difference in the way that we resolve our disputes.
Brilliant. Thank you very much. Please join. Yes.
Just to add something on neutrality. In this building, in this room, we have many eminent judges. They are faced with disputes every day. Fact is, all human beings have biases. Biases because of the way you were brought up, biases because of your religion, biases because of personal experiences. But when you sit as a judge, when you sit as a mediator, when you sit in the tribunals, you must deliberately work at being impartial. Try and keep your biases to the back burner. And it is a deliberate effort. Thank you.
Thank you very much. Thank you. Anybody want to add anything to that?
Yes.
Janet, very quickly.
Yes, I wanted to address a question on gender. And in terms of bringing on board gender and perhaps affirmative action to the extent the gender specialist is looking to get, Kenya is a signatory to the Dublin Principles that incorporates integrated water resources management into water resource management. One of the principles under those, the Dublin Principles, is incorporation of women. And to that extent, then, it acknowledges the role of women in ensuring and sustainably managing and accessing water resources. So to that extent, yes, Kenya has extensively incorporated that aspect. And towards that, again, towards the community, the incorporation, then we also bring on board women towards ensuring gender parity in committees that are looking towards community projects that look to benefit communities, intentionally looking at comments from women who in some communities or vulnerable communities walk very long distances to get water, and their social views are taken into account when putting in place community projects.
Thank you. Judge, you want to have the last word?
Yes. The kind
Second
of
last word.
disputes we are getting as courts on climate change litigation revolve around non-disclosure, where multinationals are not disclosing to the locals what they have found on the ground. Number two, where states have not met their targets under the Paris Agreement. And number three, where mitigation measures, adaptation and resilience measures are not there. And number four, we're also getting cases where companies versus companies competing for extraction of minerals are fighting each other. And then we are also having cases where, for example, there is extraction has not happened drilling has not started, but how much is it, for example, you have found, on the ground? How much information can you disclose to the regulators? These are complex cases, and that is what we are saying. Even as you want to mediate climate change disputes, it is not about water. It is multifaceted. And even when you are bringing those agreements to court to be enforced, there are parameters which the court must look at, whether the agreement passes the test, the constitutional test. We are not saying that what you are doing is not good enough, but we are saying even when you bring that, agreement, mediation settlement agreement before us, the law says that we must look at these parameters. Does it pass the human rights test? Does it, pass the morality test? Does it pass, the justice test? Those are the things which we look at as judges and judicial officers. Thank you.
Thank you very much. Thank you. Teresa, do you have anything that you wish to add, or are you?
Because you asked. Thank you
Yes.
very much. I think I just want to say two things. The first, I think I would like to respond to my sister mediator who said, how do you deal with bias? And I think the question has been responded to that, you cannot run away from your biases because they inform, they shape who you are. And I think in your role as a mediator, maybe the advice, because I'm not one, is to then acknowledge that you have those biases. And maybe as you frame issues, for mediation, you are then able to some degree be informed. Because I think the important point that Prof has raised is that, especially where you're dealing with, multinationals and with what's happening now in the climate change space, a lot of times what corporates are doing is to come to communities to greenwash, right? They're using communities to come in and create carbon sinks without disclosing the same. So I think it's also incumbent upon those that are going to be mediating, especially if you're going to be dealing with climate change, environmental law disputes, to be informed, so that even as you frame the issues, when the agreements then come to court, they are able to meet the tests of morality, of justice, of fairness, of equality, and of participation. And I think the second thing that I would just like to say is that we cannot overemphasize, for those of us that have the opportunities and the platforms, to really promote literacy around matters of climate change. Because as Prof said, Africa is allegedly the poorest continent, but right now the climate politics is playing out on African soil. And it is incumbent upon those of us that have access to platforms to be able to share information so that people are informed and are able to engage from a perspective of information and power and agency, because this is our continent. Thank you very much.
Thank you very much. In my unbiased view, this has been an excellent panel. Please join me in a hand clap for this panel. Thank you very much for your very, very thoughtful responses. Thank you, and I hope you enjoyed the panel.
Thank you so much, Senior Counsel. So that we move right into the gifting of this panelist, I'm going to invite Honorable Justice G.V. Odunga to help us award or give them a token of appreciation, probably not award. We'll start with Prof. Kariuki Muigwa. Let's appreciate Prof. Thank you so much, Prof. Justice Christopher Nzili is next. Let's appreciate the good judge. Ms. Teresa Mugadza is next. Thank you so much, Ms. Teresa. Honorable Kyoko Kilukumi, Senior Counsel, thank you so much. Senior Janet Olewe, thank you so much. Miss Lois Chisompola. I hope I got it right this time. Thank you so much. And Senior Counsel John Ohaga. Thank you so much for the great work moderating this panel. So please allow me to move right into the next session, which is a discussion on the way forward. And I would like to request your help in welcoming Honorable Lady Justice Christine Ochieng, who is going to help us with this part. So Honorable Christine, Lady Justice Christine Ochieng is the presiding judge of the Land Division at Milimani. Thank you and welcome, Judge.
Good afternoon. After the two or 3 day deliberations, are you happy? Are you happy with the content of the training, the sharing, the panelists? And we are craving for more, isn't it? Okay, we've tried to reduce the feedback that we are getting from the panelists and from the participants into a communique. It's very brief, so in case your issues are not captured, there might be particular thematic area. So you just have to listen keenly. But before I share the communique, I'd like to invite Justice Odunga to come up front because I want them to be present when I'm reading it because they'll be signing it. Justice George Vincent Odunga, Justice Oscar Ngote, RPJ, Dr. Elizabeth Gashenga, the DVC, and Mr. Chacha, one of the mediators who is the chair in Nairobi. Mr. Chacha. And I've been told that time is not on our side, but it's just, you'll have to appreciate that it's only 2 pages, and I'll take us through. ICT, can you please, ICT? This is the one. Yeah, you'll give them, you'll help me. Okay. I may proceed, thank you. And this is the joint communique of the Court Annex Mediation, Environment and Land Court and the stakeholders at the end of the 2025 Mediation Summit on Land Use and Climate Change Disputes in Kenya. And the theme was enhancing access to justice and promoting a more cohesive society through the use of mediation in resolution of disputes relating to land use and climate change in Kenya. And it was held, the meeting was held from the 9th to the 11th of April 2025 at Strathmore University. And I'll start that the Court Annexed Mediation, Environment and Land Court of the Republic of Kenya, the ELC, the national government, county governments, state agencies, development partners and academia, private sector, and all delegates here collectively referred to us as stakeholders of the Court Annexed Mediation, participated in the 3rd Mediation Summit themed Enhancing Access to Justice and Promoting a More Cohesive Society through the use of mediation in resolution of disputes relating to land use and climate change in Kenya, held at the Strathmore University, Nairobi. Commitment to mediation. Reaffirming the dedication to using mediation as a primary tool for resolving disputes related to land use and climate change, thereby enhancing access to justice and reducing case backlogs in line with Article 159(2)(c) of the Constitution of Kenya 2010 that recognizes the place of alternative dispute resolution, ADR processes, including mediation. 2, stakeholder collaboration, emphasizing the importance of collaboration among the Environment and Land Court, mediators and stakeholders to ensure effective and inclusive dispute resolution processes. Integration of climate governance, recognizing the need to integrate climate governance into mediation practices to address the environmental impacts and promote sustainable land use and support for vulnerable communities, highlighting the commitment to protecting the rights and welfare of vulnerable communities, including women and youth affected by land disputes and climate change through restorative justice measures, ensuring compliance with Article 48 of the Constitution of Kenya 2010, which entrenches every person's right to access justice, and capacity building and training, advocating for continuous capacity building and training of mediators and stakeholders to enhance their skills and knowledge in handling complex land and climate-related disputes, thereby promoting access to justice. Drawing from the reflections and themes of the 3rd Annual Mediation Summit, the Environment and Land Court ELC, partners and stakeholders recognize the role of mediation in dispute resolution, do hereby resolve and commit as hereunder. This is where I want us to be very keen, because we are all stakeholders in here. Land use, environmental and climate change disputes, apply mediation as an effective tool that tackles conflicts related to climate change by integrating governance, addressing the environmental impacts, promoting sustainable land use, and fostering peaceful resolutions and for the parties involved. 2, access to justice by vulnerable groups, including women and youth. Enhance access to justice through mediation with a specific focus on the rights and welfare of vulnerable communities, ensuring inclusivity, fair power dynamics, and the provision of legal representation where needed. Legal and policy framework for mediation. Recommend the ratification of the Singapore Convention on Mediation 2019. This to the government of Kenya. Review the Land Policy 2019, because it's due for review, to include mediation as a dispute resolution mechanism. Recommend the fast tracking of the approval of the national ADR policy. There's a draft policy, we want it to be approved. And enactment of an act of parliament. There's a bill in parliament, and all this is under Article 159 of the Constitution that promotes alternative dispute resolution mechanisms. Number 4, stakeholder and institutional collaboration. Enhance collaboration among various stakeholders, including ELC, mediators, state and non-state actors, including professional bodies. Number 5, capacity building and training for mediation. Undertake continuous training for mediation, because this is a key point that has come from the day before yesterday. Judiciary and stakeholders to enhance their skills and knowledge in handling land and environment-related disputes. 6, public awareness and situational mediation. Conduct campaigns to educate the public, dispel misconceptions, and emphasize the benefits of mediation. 7, culture and traditional dispute resolution mechanisms. Embrace traditional dispute resolution mechanisms and align them with the Constitution. We have to remember that under Article 159, there are other mechanisms that we cannot actually disregard. Number 8, community and ancestral land disputes. Adopt specialized and creative approaches in mediating these disputes so as to achieve restorative justice, because that is actually the key, the theme for mediation. And then number 9, enforcement of private mediation agreements. Foster private mediation, the ones that are not done by court annexed, and their registration in court to facilitate recognition and enforcement. And number 10, promotion of research and linkages on mediation. Enhance South-to-South collaborations and foster global exchanges and research. And here we need to appreciate and give a standing ovation to Atieno, Judge Atieno here. We have to. Can we all rise up for the sake of Judge Atieno, please? And just give Judge Ann Williams. And you can have your seats. Thank you. And with that, I'd like Justice George Odunga to sign, because he's the chair of the Mediation Accreditation Committee, to sign first this communique. Yes. Sorry. Yes. You take it to them. Yeah, take it to them. They'll have to sign one. They have to sign one before. Yes, please proceed. Can you, Eddie, dear Omolo, please give him the microphone, please.
Thank you so much. I raised my hand to object the signing of the document, and I have a reason. I represent people living with disabilities as their president in Kenya. And that document does not touch on people living with disabilities. It's only women and youth. So before we sign, I will request we amend.
Yes. Can we have one meeting, please? He's given his feedback. If you have feedback, just raise your hand and you're given the mic. And we'll include it. We'll include it under number 2. It might be to read it number 2 again for your, I'd said access to justice by vulnerable groups, including women and children, enhance access to justice through mediation with a specific focus on the rights and welfare of vulnerable communities, ensuring inclusivity. Because when you start breaking, widows and orphans will say you want it to be.
The parliament signed a new law on persons with disability. We are not under the vulnerable in the community. We are people with disabilities, and we need to put it there clearly. Vulnerable, we have orphans. We have old age. But people living with disability, we are categorized. And we are 6 million in Kenya. So we cannot put it as a vulnerable. I will not agree that.
I request that because time is of essence, we can defer for a few minutes, do the closing, then they'll come and sign it when we're including that paragraph. Yes, if that's okay? Okay, thank you very much. MC? Excuse me? The person signing have said we'll sign, they're actually correcting, we'll sign with amendment, then we'll change the page if that's okay. Can we proceed that way to save on time? So we are going to say access to justice by vulnerable groups, including women and youth. Enhance access to justice through mediation with a specific focus on the rights and welfare of vulnerable communities, persons with disability, ensuring inclusivity, fair power, dynamics, and the provision of legal representation where needed. So with that, the persons are signing, and then we'll be able to share copies with the respective parties. Thank you very much.
Thank you very much, Judge Christine Ochieng, for taking us through that session. We are coming to the tail end of our program, and you have been a wonderful audience, a wonderful participants. Thank you, Chair from the people living with disabilities, for raising that issue and ensuring our document leaves no one behind. We are now going to do the closing ceremony as our communique is signed. And I'll ask Judge Ann Williams, please step up to the podium for the closing ceremony. I'll also request that the bench, which is the panel, which is signing, remain on the, remain there. Okay. So they'll take a photo with a signed copy of the communique. May I also request Judge Mongo, you can also come for the photo to represent the task force. Justice Ochieng is not there today, but well represented by Justice Mongo, PJ Emeritus. I'll also request, so that we don't leave anyone behind, Senior Counsel Ohaga, can you represent the lawyers in the room? For the photo. And also Director Lasoi, please come on board and also represent the others. I'll request that you stand up. The photograph, John, you'll guide us, please, John. Yes. You're part of the team. Sit there, you're the secretary. You're part of the team. Thank you very much. Thank you. This is the fruit of the 3 days we've been here. We can see all the work we were doing, all the sessions they have built into that communique. Can we celebrate the work we have done in the last? Have the ladies helped me? The ladies helped me? Thank you very much. I'll request the panel, please sit so that we just do a very brief closing ceremony. Yes, Dr. Elizabeth, you can just have a seat. Yes. May I request that we welcome to the stage Judge Ann Williams, aka Atieno Wango Chebet. I thought we'd be lulating by now. Just to give us her final word. What?
Sante Sana. I guess I was so moved by that wonderful signing ceremony. Can we all give another round of applause? Mediation bringing the light. The light is mediation. Can we say that again? Mediation bringing the light. The light is mediation. And say it like you mean it. The light is mediation. One more time. One more time. Mediation is the light. The light is mediation. Because mediation unlocks justice, it gives equality, and it gives peace. And along with Justice Joel and Ngugi in the alternative justice system, where mediation is being taught in the villages, we are all together in this mission of before you right, Judge. So I now have 5 Kenyan names. So Atieno Wangu Chebet, yesterday Mwende loved ones, and I said, I have to still keep Zawadi last because it looks like I'm gonna have a Kenyan name for every letter in the alphabet. So I want Zawadi to be last. So from Atieno to Zawadi. I also want to bring to the stage, Judy, this was just a slight change. Another Kenyan, Shabai. She's here, Damali Peterman, who has led our training in this second cohort. And if she could just have a short time to tell you what this meant to her, because she is bringing the light. This is her 4th time coming back to Kenya. And so she's going to also need a second and a third name. Shabai.
Good afternoon, everyone. Good afternoon, everyone. Now that feels more like it. It is truly an honor to be here in Kenya, a country that I deeply admire and where I truly feel at home. Surrounded by people who are not only committed to peace, but who are building it one conversation at a time. I am humbled by the introduction, Judge Atieno, to be called the light of mediation. And coming from you, it's one of the greatest honors of my life. Thank you for seeing me, inviting me on this journey with you, and for all the incredible work that you do. I appreciate you Judge Atieno. Before I begin, I want to acknowledge that I too have Kenyan names. I have come here 4 times, and finally I have some Kenyan names. So my first name is Wendo, which I've been told means love. And my second name is Chabaibai, and I was told I have to say Chabaibai like this. Is that right? Chabaibai. That's right. So Wendo means love, and that's exactly how I show up, in love with this work, with this country, and this calling. So I just want to say that I stand before you with a lot of gratitude, a heart full of it, in fact. First, to Judge Ann Williams, thank you for bringing me here. Your tireless vision and commitment to advancing mediation in Kenya, across Africa, and around the world is inspiring. You are our beloved Lady of Justice, and you are the light of mediation for me. I'd also like to express my gratitude to the Kenyan judiciary under the leadership of Chief Justice Martha Koome. Thank you for boldly championing mediation. Special appreciation to Honorable Kendegor, Honorable Sitati, Honorable Mathoni, and the entire judiciary team for your unwavering dedication and support. To Strathmore University, thank you for opening your doors and your hearts to all of us. Special recognition is given to Dean Jane Wathuta of Strathmore Law School, Dean Emeritus Peter Quinjera, and the amazing Marianne and her team. Thank you for giving each of us a warm welcome and a very wonderful space to host the mediation trainings and the summit. To the mediators across the country, you are the heart and soul of this movement. Thank you for showing up again and again with curiosity and courage and compassion for those who entrust their conflicts to you. I am humbled to have a very small role in the mediation movement here, and what a movement it is. Kenya is leading a powerful global shift. Mediation is no longer simply alternative dispute resolution. It is, as I've heard another speaker has already said, African dispute resolution, deeply rooted in traditions, grounded in community, and guided by respect and restoration. Litigation is becoming the exception. Dialogue is becoming the default. And that is something to celebrate. So please clap for yourselves. Mediation is not just a method, it is a mindset. It empowers us to see one another, to listen deeply, and to choose peace over power, connection over conflict. It is practical, profound, and profoundly African. I am proud to be a part of this journey, and I'm proud to be here before you today. So let us keep walking this journey together, training more mediators, healing more communities, and transforming conflict into connection. The world is watching, and Kenya is showing the way. Thank you.
So I'm so happy Shabaibai gave all the thank yous, because it's really been incredible. And I do want, and we have the Vice Chancellor here, and so I wanted to just present her with a box of chocolates from Kohl's Chicago, but I promise they're sweet. I've already given the sweets to the Chief Justice, but I have to, Honorable Satati and Mathoni, oh my God. All the calls we had, all time of night, they're trying to get me, I'm trying to get them. They have left no stone unturned. Can we say this third summit has even gone higher than we have been before? So, So I said, you know, mediation is bringing the light. The light is mediation. And one final thought. You saw that document signed, and in my notes, I was going to say, this is an action summit. Can you say that with me? This is an action summit. Say it one more time. This is an action summit. This isn't just words that we're going to forget when we walk out the door. We all have something to do here, and we're going to take action because we believe in mediation and we believe in justice and equality in every corner of Kenyan life. Do we believe? Yes. Can you say we believe? We believe that mediation can lead us out of the storm, the litigation storm, and can bring warmth and peace to us all. And so I will end with one of my favorite songs, which happens to be called I Believe. I believe for every drop of rain that falls, a flower grows. I believe that somewhere in the darkest night, mediation glows. We believe mediation is the light. Mediation will grow. We'll make it so. CJ Comey believes, people-centered justice believes, we believe. I believe above the litigation storm, mediators' prayers will still be heard. I believe that big judge, big mediator, big God, big Allah, in the sky somewhere, hears every word. Every time we hear the parties say, we'll work it out, we'll have a deal, a settlement, then I know why I believe. Every time we hear the parties say, we'll work it out, we have a deal, a settlement, then I know why CJ Comey believes. Then I know why the ELC judges believe. Then I know why all the judiciary believe. Then I know why all the mediators believe. Then I know why the Kenyan Bankers Association, Weinstein University, Jones Day, LAS Breakthrough, ADR. I know why we all believe. Then I know why Damali Strathmore believes. Then I know why advocates believe. Then I know why mediators and TOTs believe. Did I forget anybody? Then I know why we believe. Asante Sana, see you next year, 4th Summit, Family Law. Amen. Amen.
Thank you very much, Judge Williams, Atieno Wango, Chebet, not Chebaibai. Mwende, thank you very much. Allow me to call upon the Principal Judge of the Environment and Land Court, Justice Oscar Ngote, to call the closing. Yes.
Thank you very much, Justice Omange. Thank you very much, Judge Retired of the Court of Appeal from the United States, Justice Williams. Thank you very much, Justice Odunga, for joining us in this closing ceremony. Thank you very much, Justice Mwongo. Thank you very much, Senior Counsel. Thank you very much, all the delegates who've been with us since we started this particular conference. I made my remarks, so I'm not going to make any remarks right now, but just to thank all of you for attending this ELC annual summit on mediation. We assure you that as a court, we are part and parcel of this process, and we are going to implement whatever we've discussed today. Now, it is my pleasure to invite the Judge of the Court of Appeal, who is also the chair of the Mediation Accreditation Committee, Justice G.V. Odunga, just to come and make his remarks and officially close this particular summit. Welcome, Justice Odunga.
With your permission, my Lord, the Principal Judge, may I adopt the protocols that you have set out just less than a minute ago. When I came here this morning, I thought I was going to say just a sentence and then sit down. But I was told that I need to say something briefly about Mediation Accreditation Committee. It's not going to take too long, so that those who are here, who may intend to seek accreditation, may be able to know what to do. Mediation Accreditation Committee is not court annexed mediation committee. I think we usually confuse the two. Court annexed mediation committee is the one that is chaired by Justice Cheng. I chair Mediation Accreditation Committee. Our mandate is simply to accredit mediators, set standards for their training, the code of conduct, and then also deal with the issues of discipline. We are actually a big committee in the sense that there are a lot of stakeholders represented in the committee. The Law Society of Kenya, Senior Counsel John Oaga represents the Law Society. We have KEPSA, we have Chartered Institute of Arbitrators, ICJ, KEPSA, the Institute of Secretaries, the Institute of Public Accountants, the Attorney General. I hope I'm not leaving any out. Okay, of course, Kenya Bankers is also a member of the Mediation Accreditation Committee. I became a chairman of this committee in 2018, taking over from the retired Judge Justice Visram. And I'm pleased to inform you that as of today, we have 1,893 accredited mediators. 1,893 accredited mediators. We have 1,112 with active status. We have 424 on mentorship. Before you become accredited, you must undergo mentorship. We have 341 inactive, and we have lost 16 who are deceased, not that they've been expelled. In February and March this year, we accredited 328 mediators. Now, the reason why there are some inactive mediators is, for example, if you're a judicial officer, as of now, a magistrate or a judge, you can be accredited, but you will not be given cases, so you remain inactive. We have a code of ethics that applies to all mediators. And this is, of course, to promote confidence in the court annexed mediation. We have a secretariat that is under Honorable Wanjala. So far, we only have nine disciplinary cases. one of the mediators has been struck off. Now, the 9 may not reflect what the reality is. The problem that we have is that sometimes these complaints do not reach where we are. You just hear them in the media, but they don't reach us. We cannot be the complainants. At the same time, the prosecutors and the judges. So somebody else needs to actually bring these complaints to us. It's in the interest of mediators that these complaints come to us, because if you have one of you who is doing the wrong thing, then the public will start believing that mediation is not working, that the mediators are doing the wrong thing, and therefore they lose confidence in the mediation. So it's important for you as a good mediator that you ensure that we come to know about this, what's happening out there. Some of these issues can be resolved just through sitting down with a mediator and discussing without necessarily imposing a penalty. It is, however, important, and we do encourage mediators to set up peer review committees. Within your regions, you set up the review committees so that these matters are dealt with down there before they come to the committee. We have, however, discovered that there are some training centers that claim to offer the 40-hour mediation training program, while they do not do so. They do not have capacity to do so, and therefore when the mediators come for interviews, you realize that they have not been properly trained. We also have instances of wrong adverts. We've seen some adverts that are not misrepresent what we actually do. I have had some instances where training centers, they have a workshop, and then they include my name that I'll be one of the speakers, when I'm not aware at all about that. So I think we need to conduct ourselves properly, whether as mediators or as training centers, and we do the right thing. We have, of course, recently implemented the private mediation. You heard about it. We encourage the Environment and Land Code partnerships with mentor representatives in the CUC. It's important that in the CUC you have a representative of mediators, so that we move together as one family. Kenya Bankers Association is, of course, have done a lot in terms of partnership in mediator capacity building. I think we have had some training with the mediators, courtesy of Kenya Bankers Association. Strathmore University has hosted our summits, as well as training programs since 2023. The first cohort of trained mediators comprised 58 who are internationally accredited mediators. I'm told that they are here with us. Maybe they just stand up so that we see them if they're here. Thank you very much. And this includes Beverly Moss and your team. Clap for them. Thank you very much. So that's basically what I wanted to say about Mark. Now permit me to apologize for not being here from day one. I always attend Mediation Summit. I was not able to be here physically because I had some official engagement outside the town. But I was being updated by the registrar, that is Honorable Sitati, on the deliberations that were ongoing. So as we come to the end of this 2025 Annual Mediation Summit, I want to express my sincere appreciation to all the participants, the speakers, the partners who contributed to its success. Your dedication, insights, and collaborative spirit are what makes this truly a special forum. Special thanks, of course, to the Chief Justice for gracing the summit and setting the climate for a successful summit. I cannot fail to appreciate the efforts that have been made by Judge Anna Williams in ensuring that we have this annual summit without fail. I don't know how we can thank her for this. There's a verse in the Bible that yours is the kingdom of God, your blessings are in heaven. Maybe that's the best that you can do, because I don't think clapping will be enough for what you've done. I'm sure we have learned a lot. Most importantly, we must appreciate that change is possible in how we deal with our disputes. We can put into action the ideas that we have exchanged in this summit to invest in a proactive dispute solution mechanism, the rule of law, people-centered justice, social inclusion, and effective and accountable institutions. Throughout this summit, we have been enlightened on the transformative power of mediation and the incredible impact it can have on people's lives. We had inspiring milestones and ongoing efforts towards the achievement of this goal, particularly in areas of land disputes, climate change, environmental issues. Peace is closely interlinked with environment. In fact, most of the conflicts we have in the world arise because of our the competition on resources, on the environment, and therefore, if we are able to ensure that we have a clean and sustainable environment, we'll be able to reduce on our disputes. It's only by working together and solving our disputes in an environment devoid of animosity can we create a more peaceful, just, and inclusive world for all of us. Any dispute at any level is capable of being mediated. In the Court of Appeal, we had serious problems with some of us about mediation being applied at that particular level. Because the reasoning was that this matter has been heard. It's been heard by the High Court as a first appellate court. And if they can't agree, how can they agree at the Court of Appeal level? Of course, there are some of us who have been involved in this process for some time, and we understand the benefits of mediation. There are some matters where you look at a matter and it's basically a matter which you cannot resolve sitting as a judge. You can't. Even when you write a judgment, still the dispute is still there. It's not going away. And therefore, we introduced Rule 108 to give the power to the Court of Appeal to also apply mediation at that particular level. And there are matters which we refer to mediation, and they've been successful. It's something that we need to embrace and encourage all of us to resort to. So let us build on the momentum that's generated in this summit, take concrete actions, and implement the lessons that we've learned. Let us stay connected, share our experiences, support one another in our common journey of making mediation the primary dispute resolution mechanism in all forms of conflicts, particularly in matters of land, matters of climate, matters of environment. Most disputes actually revolve around land. Whether you are talking about the people in the village, you are talking about countries fighting, most likely there's a land behind it. Succession matters are just land. In fact, rarely do you find any succession dispute where the deceased has nothing. It doesn't happen. The people only fight where they have something that they are going to gain from that succession. And in most cases, it's basically land. So thank you very much. May God bless you all. And see you at the next summit, where we'll focus on family disputes. God bless you.
So we must thank our leader here, Justice, for your concluding remarks and all your support and the leadership you've shown. Mediation has grown because of you and your leadership. And I also want to thank all the trainers you mentioned. We had 6 trainers from the first cohort, if they could stand. We had 3 Zambian trainers, if they could stand. We had 6 US trainers. We had our guests from Uganda, Breakthrough ADR, Weinstein International, and my law firm, all of us volunteering our time. And why? Because of the leadership here in Kenya. And so I just want to thank you so much, Justice, for being here for us. And to tell you that I do not stand alone. So I appreciate you telling me thank you, but I am just one person. And there are many, many people whose shoulders I stand on, including yours.
Thank you very much, Justice Odunga and Judge Ann Williams. Thank you very much. We are coming to the tail end of our program, and the principal judge of the Environment and Land Court has requested that we thank a few people as a court who are instrumental to this day. I know a lot of thanks have been given, but please bear with us. In this country, we are trying to develop a culture of appreciating. So you will bear with us that I will repeat some which have been thanked, but they didn't come from the Environment and Land Court, which would also want to express its appreciation. So on behalf of the Environment and Land Court, we are grateful to God who has given us the land and environment which we all enjoy in this country, but only for a time. May we all be faithful custodians, remembering that one day we shall give an account of our time here. To the people of Kenya who trust us with their cases, both in courts and in mediation, we are indebted. Special mention of the people of Mathare, who opened their homes and their hearts to us. We heard you and your aspirations for a just society, a society in which you are meaningfully engaged and in which your rights are respected. Your voice was heard in the summit through the children who performed for us here. We will walk the journey we have begun together. The participants in this room, both physical and online, thank you for being with us here these 3 days. Where many words are spoken, no doubt there is sin. Please take away the many useful and inspiring lessons that were shared on this platform. Where we add, we take responsibility and promise to do better next time. The distinguished speakers, session chairs, and our guests, both from within and outside Kenya. Special mention of our Member of Parliament, Honorable Akelo, who shared so passionately with us. She's a Luo like me, I digress. Who shared so passionately with us of their struggles in Uganda, which in so many ways mirror what we also face in Kenya. It was an honor being with you. We all have lived here with valuable lessons from each of your presentations and your experiences, which were delivered in each of your unique ways. Our host, Strathmore University, your professionalism is unmatched. Special mention of the Vice Chancellor, Dr. Elizabeth Gashenga, Dean Emeritus Kwenjera, and Patrick Zomo, our Master of Ceremonies. Not forgetting the army of ushers. I had occasion to know one called Nicole. So Nicole and her team, the logistics team, including our photographers, the students, the caterers, the ICT and communication teams, and the staff who went out of their way to make us comfortable. Many in this room, including myself, owe this university the excellent legal training that it has given our children. May you and all other universities present here continue impacting future generations. In a special way, we thank and repeat and reiterate our thanks to Justice Anne Williams, aka Atieno Wango, Zawadi, okay, Zawadi is last, Mwende, Chebet, and the list goes on. Thank you for your passion, your energy, and for bringing us all together. Your ability to look beyond the black robe, which is a challenge to all of us judges, and you are an inspiration. We acknowledge the other partners who have been mentioned, Jones Day Law Firm, Weinstein, Kenya Bankers, Secretariat of Peace Building and Conflict Management, IDLO, and Mount Kenya University. Thank you for walking this journey with us. Allow me to recognize the members of the honorable profession to which I belong, to which I also, by the grace of God, belong, the lawyers. Thank you for your service, which at times, just like the work of judges, is vilified depending on whether a client wins or loses a case. Thank you for being part of the journey of mediation and for supporting it from the start. Vice Chair Ribrin was part of the organizing team and he was here on the first day. Senior Counsel John Ohaga was one of the team of pioneers who, while watching elephants, helped design the pilot which has given birth to court annexed mediation as we know it today. I also acknowledge the significant contribution of Senior Counsel Kanjama, who was then the chair of the Nairobi branch of the Law Society when court annexed mediation was first piloted in commercial and family division. Look at what working together can do for us. Thank you, LSK, and all your distinguished members who serve in different capacities, who showed up in this forum. I won't mention you all by name. You are making a difference in our country. Our mediators, you took up the cause of mediation even when we were all struggling to find our footing. And every time we launch mediation, we tell you we are leaving you with a baby. And as we enter our vehicles and go back to Nairobi, make sure the baby does not die. You have not disappointed. We are truly grateful. As we finish, we celebrate the vision and service of Chief Justice Martha Koome, who has committed to solidifying the gains of her predecessors, and in addition has introduced a shared leadership that she has entrusted Justice Ochieng and the task force members to oversee implementation of mediation. The fruits of their work is evident in the milestones covered in mediation. Thank you, Judge Ochieng and task force members. Judge Mwongo is here. Senior Counsel Ohaga is also here. I've spoken about him. But what we also might not know is that Judge Mwongo was then the principal judge when this team, which was looking at elephants, designed the pilot rules for court annexed mediation. Thank you, PJ Emeritus. I must also mention the great work of the AJS task force led by Justice Ngugi, which is all part of the greater, bigger ADR journey. Allow me to recognize the Court Annexed Mediation Secretariat, headed by Honorable Grace Itati, who has just successfully concluded her first summit as a registrar. Thank you. In what is the hallmark of transitions in the judiciary, it is another successful and peaceful handover of power from Justice Kendagor, who served with distinction as registrar. We appreciate her in absentia. Honorable Sistati, you have taken over the mantle well. All of us in this room look forward to working with you as we take court annexed mediation and indeed mediation as a whole to the next level. The Secretariat was supported by deputy registrars and heads of stations in our court stations, who all supported the judges in carrying out the various activities at station level. You are our unsung heroes and heroines. We are grateful to you. We are grateful to you and our staff who have worked behind the scenes. We do not forget the Office of the Registrar of the Environment and Land Courts, Honorable Makungu, which worked with the Secretariat, with Court Annexed Mediation and Strathmore to organize this summit, and of course the other stakeholders. Last but not least, our Principal Judge, Justice Oscar Angote, thank you for leading from the front and leaving none of your judges behind. You're a great team leader. And to my colleague judges, thank you for the work you do, for your active participation in this forum when you could have been writing judgments on your recess, and for your commitment to ensuring that justice is our shield and defender at all times. I pray for strength and for wisdom as we continue to serve. As we leave to our various destinations, we wish you journey mercies. Please continue the mediation course, all of us. We are stronger together. Mediation works. Thank you all, and God bless you. Again, in the spirit of appreciation, we have some gifts from the Environment and Land Courts to celebrate, or just to say a token to very few of us. If you don't get a gift, we still love you. We still appreciate you, but we could only appreciate so many people. So I'll call upon Honorable Justice Annette Nyikuri to come and help us gift somebody who was very patient with us here. I know I hogged time. I'm a daughter of teachers, but he kept us on course. And he told us, please, let's be very gracious, even as he tried to keep us all on course. Patrick Nzomo, we wish to give you a gift. Thank you very much. Thank you for your patience. He did it with grace, isn't it? And he did it very well, very peacefully. Thank you very much. Thank you very much. We also want to appreciate the Secretariat that worked in organizing this. And we want to mention there were many people. It was an army, so we're not appreciating everyone. But please, let's appreciate Marianne by giving her a small token of our appreciation. Marianne, we can all agree everything has run seamlessly. Is she here? Or she's busy looking out for something for us? Thank you very much, Marianne. Oh, sorry, this was Grace Sitati to give. Honorable Grace Sitati, you worked with her. Please give her this gift. Sorry, Judge. Sorry, Judge. Honorable Grace Sitati will hand over this gift. Then we want to also appreciate our Dean Emeritus, Dr. Kwenjera. He's been all over the place, running up and down. He reminds me when I used to be the Registrar of the High Court, running everywhere. Thank you very much, Dean. Your work has been very, very useful, and we celebrate it. Who is giving Dean? Judge Grace Kemei. Please help us with that gift. Thank you. You're welcome. And now drum rolls. As the mediation team, if you wanted to sing, this is your moment. If you lose it, now don't ask me for another chance. People want to eat lunch. I want to now appreciate, we also want to appreciate Judge Ann Williams, Atieno Wango, Chebet, Mwende Zawadi. Please, I ask the Principal Judge of the Environment and Land Court to help me in this task.
You can go downstairs. We have 2 gifts for you. One will be given by the principal judge. The other one will be given by Justice Mongo. As the mediation team sing for us. So you can allow the gift to be given, please. Then now you sing as she sits down. I mean, as she sings with you. Or you want to form a buffer around her? Okay. We will flow with this one. We will flow. We'll allow it to flow. Sorry, can it be handed over for a photo? Okay, please help me. Do we take a photo first, then now the singing goes on? Okay, thank you, please. So just move, just part like this, part like that, so the photo is taken. So Judge Angote will give 1 gift, and then Judge Mongo will give another gift. Sorry. Allow me to give a disclosure. The Honorable Chief Justice has given you a book, one of the gifts in the pack, which she has authored and she has signed for you. Thank you. Yeah, thank you. Patrick. Thank you very much. So I want to make final announcements, because once you sing, you will also pray and we all go. So I won't come back up here on the stage. There's a key we found yesterday. If you have lost your key, or you know your friend who has lost, please see Patrick Zomo. There was another announcement which I've forgotten. I think that is it. Have a good day, everyone, and take it away, the mediators. Thank you.
Right. The choir master is here. So we will go like this. 1, 2, then we go. Sawa sawa. So 1, 2, go. Tunawapenda kama mediator. Tunawapenda kama mediators. Tunawapenda sana. Tunawapenda sana. Tunawapenda kama mediator. Tunashukuru kama mediators, tunashukuru kama mediators, tunashukuru sana, tunashukuru sana, tunashukuru kama mediators, tunawapenda kama mediators, tunawapenda, tunawapenda, tunawapenda kama mediator. Tunashukuru kama mediator. Tunashukuru kama mediator. Tunashukuru. Tunashukuru. Tunashukuru kama mediator. Mbarikiwe na sana sana. Mbarikiwe na sana. Mbarikiwe. Mbarikiwe sana. Tunakupenda kama mediator.
Okay, just a minute. We now sing the rendition that you knew. Yes. That one was yours, isn't it? So, Daisy. Kama mediator, kama mediator.
Tunawapenda
kama mediators,
kama mediators,
tunawapenda
sana,
tunawapenda
sana,
tunawapenda
kama mediators,
tunashukuru kama mediators,
kama mediators, kama mediators.
Thank you.
Thank you.
Sorry, I promised I would not talk again, but we need to give some.
And
we need
I
to
did
appreciate.
not cry until I heard those songs, Asante San.
Thank you. We just have one more before you pray. Who is praying? Please just come up ready.
I'm the one praying.
Okay, so you'll come up. I just so that I finish with the other. Yeah, we have some more gifts. Strathmore have also gifted the panel for today. I've gifted them. Why is it having an echo? Okay. Allow me to. Thank you, mediators. Allow me to call upon Judge Sila Munyao, if he's in the house. Judge Sila Munyao, to present a gift to to Dr. Elizabeth Dashenga. Yes. Thank you very much. Let's appreciate Strathmore and the Deputy Vice Chancellor for the excellent support they gave us. I'll then also call upon Judge Ano Molo to also gift Judge Odunga. Is Judge Ano Molo in the house? Judge Ano Molo is not in the house. Allow me to call upon, who do I call upon? Senior Counsel Haga. You can help us with gifting Judge Christine Ochieng. We can clap for the judge as they come. Judge Christine Ochieng, who did a wonderful job with capturing the communique very succinctly. Well. Last but not least, Judge Mary Oundo will give Judge Odunga his gift. Let's clap for Judge Odunga. Thank you very much. We have now finished, except for something to do with the certificates, which Dean Kwenjera will announce, emeritus. But as we finish, we have been wonderful participants. Let's appreciate ourselves just in this way. This way. No, this way. You put your hands like this. Then you're gonna give yourself an oh yes, okay? Let's do oh yes. Thank you very much.
Good afternoon. Thank you so much for staying the course. Thank you so much for trusting Strathmore and Strathmore Law School with this event and with this summit. We don't take it for granted, and we will stay accountable for that trust. I have been told that as the academician in the law school, there are people who want certificates. So one thing I want to say is that we had 1,004 persons register for the summit. 390 of us registered to be here in person, and the rest, my mathematics is not working, 614 are online. I've been monitoring the numbers there, and I thank the online team for really staying put for the 3 days. So why I'm saying that is because, of course, it will take my team time to sort out the certificates who attended. We are a bit strict on attendance here. So those registers you signed, we are going to go through them with my team. And then if you attended to our satisfaction, then we will issue the certificate. Yeah, the Strathmore rule is that it is a 2/3 attendance. If you don't meet the 66.6666% attendance, then you didn't attend. So we will go through the register, and then we shall communicate. If there are any queries, what I would say, give us about 2 weeks. We should be able to finalize that exercise, because we want to take it seriously. And I'm happy that most of the people in the room have been here with us, have been seeing you. So those of you who are here, most of you, you'll get your certificate of participation. So no problem at all. Those of you who ask for a physical certificate, not an e-certificate, we have agreed with the secretariat that once we prepare them for mediators, we will leave that at Milimani, and we shall communicate to you that you can pick it. For the ones who ask for an e-certificate, we'll be able to mail it to you to the email address that you used to register for the summit. In case you have any question, there is, of course, all of us received an email from the summit organizers giving you details about what to do here in person, or giving you details about the Zoom link for in person. So please, that same email that was sent to communicate to you, please feel free to just write an email to the organizers, and then we will sort it out. So that should not be an issue. For the lawyers in the room, there are 2 CPD points. And once again, in the same token, it will take us about 2 weeks to sort out the list, but it will not be exactly 2 weeks, because there is normally a lag between us and the LSK, because they also, there's something they have to do so that you get the point. But we will try to be very quick about it. So let me make a political promise in about 3, political, please take note of that. Now in about 3.5 weeks, plus or minus a month, no, that's a joke. We will work very hard to make sure we get that. Yeah, and I don't think there was any other issue I was supposed to address. Let me just see there. Then just in case, we have some books from the Strathmore University Press to my left as you exit. If you're interested, please take a look. There is one book I recommend, and it is a book called Learning to Live and Let Go. In case you're feeling stressed by anything, Learning to Live and Let Go, you will not regret having it. And then I need to say this. Let me just take that picture. 1 minute, please. Then we have the book by our very own Justice Asenath, The Making of a Judge, is also on sale right outside here. So please get yourself a copy, and the other books there that you will see on environment and land, on many things there, just a few titles that we have. So I thank you all, and I don't know, Nzomo was joking that I pray for lunch. Oh yes, then we have, but Damali has many books. Maybe Damali should just come and tell them the title, please. Please come. Yeah, I think it's great that you tell them the title of the book, because it's about mediation, negotiation. Do you want to tell them the title of the book? Just come.
I think Dean was tired of being in the spotlight, and he wanted me to come up here and share it with him. Don't you agree? Isn't it? Yes. My books that are here in Kenya are called Be Who You Are to Get What You Want. It's about negotiation and mediation. And then the other book that some of you have also ordered is called Negotiating While Black, Be Who You Are to Get What You Want.
So I had you over to the MC so that he can invite you for a lunch and with the final prayer. Thank you very much, and welcome to Strathmore again and again.
Thank you so much. I'm just inviting the person who will pray for us. And it's been nice being with you for the 3 days, and I hope we see more of each other in the coming days. Thank you so much.
Thanks so much, sir. And for those who are wondering whether it's a wig or natural hair, it is natural hair. And also Jeremiah 46 and verse 17 says that about Pharaoh, he said, Bible says, and there they will exclaim that Pharaoh was only a loud noise, but he has missed his opportunity. So whatever opportunity that comes your way, just grab it and learn with it. That will never be said that we were here and we lost an opportunity. Let's rise up for a word of prayer. You can look at somebody, tell him or her, thanks so much for coming, and thanks so much for coming, thanks so much for coming. Even somebody behind you and another one in front of you, touch somebody, tell him or her, thank you so much for coming. And I look forward to seeing you in our 4th annual summit, the 4th annual summit, God willing, next year. Now we can be attentive for prayer. Thanks so much. I am Bishop Samboro Maderi. I'm an accredited mediator and also an international mediator. Let's pray now. Let us pray. Let us pray. In the name of the Father, Son, the Holy Spirit. Heavenly Father, we want to thank you for those 3 days. Thank you for the gift of life. Thank you for the gift of the Holy Spirit. Thank you for enabling us to be here for that time. Thank you for those who have spoken unto us and for us who have attentively listened to God. Help us not only be hearers, but also doers of what we have learned, what we have heard. We want to thank you for everything, for the stations that we work. Thank you for those who are looking upon us for instructions and direction. Thank you for the facilitators. And thank you for everyone who have done something or said something. We want to thank you. Even as you go back to our places, those who are going to go for journeys, long journeys, we ask for journey mercies, oh God. For those who are going to go for shorter journeys, we also ask for journey mercies, oh God. Be with us, oh Father. Even for the food that is prepared for us, we receive it thanksgiving. Remembering there are those ones who don't have anything to eat, we pray for thy mercies to be upon them. Be with us, oh Father. When you bring us back here in the 4th summit, we thank you and exalt you and declare these the doings of the Lord. Thank you, Father. Go with us and may that will be done. In the name of the Father, Son, the Holy Spirit, we pray. Okay, now we add with the words of the grace, and now with the grace of our Lord Jesus Christ and the love of God, the fellowship of the Holy Spirit, be with us now and forevermore. Please make sure you have known 10 people from here and tell them thank you for your coming. Also, exchange your business cards. God bless you.